All right, we are live. Welcome, everybody. We do this every single Wednesday, 1 p.m. California time, 4 p.m. Eastern time. And today I am in California. We have Samir with us. Samir, if you want to do a quick intro for people who may have not watched our
Sure.
past. Yeah.
Of course. Hi, everyone. Samir Kedekar, immigration lawyer out of Silicon Valley. I wish I had Yudi's mood lighting. That's just such a nice kind of atmosphere you've created in your studio there. It's one of my hashtag goals
Yes.
for my video setup here.
I can swing by. I can help you.
Yeah.
Yes.
I have a ways to go apparently. So
Yeah. No, you're not that far. Okay. I know we want to talk about like Bulletin just came in. Maybe for people who are like extremely new, because I am aware of what is Visa Bulletin. But maybe some people who don't know, this is the first time they're hearing like, what are they talking about Visa Bulletin? Maybe you start there and then what's like, what's going on? What's the latest update?
Yeah. So if you don't know about how the green card process works, right, there's an annual quota that the government has. Well, they created it in the 90s and have not updated it since. Can you imagine a green card quota created in the 90s to reflect how the world worked, how the economy worked back then, that has not been updated, which will explain why mostly Indians are caught in this 150-year backlog, right? Because it doesn't reflect our current economy. But that being said, there's a certain number of green cards that can be awarded to employment-based applicants every year, right? The number is somewhere around 150,000 or so. Okay, so the way the government ensures that they meet that quota, they don't actually they do count how many green cards they've awarded, but they also are trying to set people up to apply such that they meet the quota every year. So what they do is that they get a monthly report from US. So we're talking about the State Department now. Okay, this is a different department, the department that oversees the US consulates and embassies, and they're in charge of visa number issuance, right? So they get monthly reports from USCIS as to how many I-140s, which are the employment-based immigrant petitions, right, are approved every month and in what category. Okay. Then based on these reports, they basically project what the demand is going to be for visa numbers. Okay. And then based on that, it's kind of like a dam controlling the flow of water into a reservoir, right? They try to control the flow of applicants into that quota. And the quota filters through the preference categories, like first preference EB1, then second preference EB2, then third preference EB3, right? So the State Department announces their projections on the monthly Visa Bulletin, which you can Google to see.
Yeah.
And the way the Visa Bulletin works, we can do a whole lesson on this. They have dates, right? These are, you're going to put it up for beautiful. Look at that. It's come so prepared and professional. So you can see the Visa Bulletin has a family-based category, and then if you keep scrolling down to the employment-based.
Yeah.
So maybe we'll skip family-based for right now and go to the employment-based, which is right there. Yeah. So you can see this is the final action dates for the employment-based, right? We have per country limitations on green cards, meaning only a certain percentage from each country, if you just keep it there for 1 second, can get green cards every year, right? So because there are more applicants from India and to a certain extent China than any other country, right, they have the longest lines, which makes sense. And this is not what country you're a citizen of, it's what country were you born in. Keep in mind, it's also what country your spouse is born in. So if you're born in India, but your spouse is born in Canada, you can use the Canadian chart, which is on the very left side, the all chargeabilities areas, or in other words, the rest of world, or ROW. That's kind of what we call it, right? So what do these dates mean? You have to compare these dates to your priority date, your place in line, which is on your I-140 approval if you have one. If you don't have an I-140 approval, you don't have a priority date yet. You don't have a place in line. But let's say you're EB1, okay? And your priority date is, let's say, India, February, let's call it April 1st, 2022. Okay? That means you're not current under the final action date, right? That means you are not eligible to get your green card yet. And it usually means you're not eligible to apply. But if you scroll down now to the dates of filing, there's two charts, okay? They created this second chart because people are waiting so long for the final action dates to clear. They're like, well, why not allow some people to at least apply for the green card? They may not get it approved, but at least they can get the EAD and advance parole, right? So if you look at the EB1 date for India, April 15, 2022, right on the nose. If that's your date or any date
prior to
that, right? Well, are you looking? This is the September. Actually, you're looking at the September one. If you go back and look at the October, excuse me, look at the October date. Just see if you go back on your browser.
Oh, just go back.
Go back on your browser. Go one page back because you're looking at the September visa bulletin.
Yep.
And then pull up the October one. There you go. This is for next. So the October is the beginning of the fiscal year. This is important, right? Because they kind of reset their projections every year. So now you're going to see the difference. Okay, if we scroll down to final action dates, about the same. Go to the final action date, one up, a little further up. Yeah, the final action date for EB1 India is still February 15, 2022. But look at the dates of filing. If you scroll down to the next chart, that's where it is. April 15, 2023. It moved up a full year. You see that?
Yeah.
Okay. So that's it. That's the development we're talking about. That there are people who were in that 1 year period. They have an EB1, and their dates are somewhere between, they're before April 15, 2023, right? After February 15, 2022, right? But because, and then if you scroll up a little bit more, every month, go down. In between the two charts, there's a link. Yeah. So if you click on that link, the hyperlink, that'll tell you which charts. I told you the two charts, right? Well, which one do you listen to? Every month they tell you which one. There's a separate window that opened up. I don't know if you're able to show that to us. But on that window, it'll tell you which chart to look at. So for the current month, that's September, employment-based filings, you must use final action dates, right? That's the least advantage, or like the lesser advantage date. But next month for October, what does it say? For employment-based preference categories, dates of filing. So what they're basically doing is they're opening up the dam a little bit, and they're letting in applications to flow through. Do you understand? That otherwise would not have been able to apply.
Yeah.
So that's the visa bulletin development that happened here, is that they're letting more people apply. Now, next month in November, we don't know. They might say, no, we're going back to final action dates. Keep in mind, you can apply for a green card if your window opens up, okay? But you cannot get a green card approved until your priority date is current under the final action, the bulletin. You understand? So people that are applying for green cards now who have the opportunity to do so in October, may end up having a pending green card for several years, right?
Yeah.
Okay, but it gives them the EAD, gives them the advanced parole, and the possibility of having some more flexibility in between jobs. Okay,
and when you say this is when you say apply, but wouldn't you have already applied for green card? So if
remember, you cannot apply for the actual green card, the I-485, until your priority date is current.
Okay, so I-140 is something you apply.
Think of the I-140 as like a request to get a place in line for the green card, and for permission to apply for the green card. Okay, and then once you have your place in line, when your I-140 is approved, then you have to wait for that place in line to come to the front, right? I.e., it needs to be current under one of these charts to actually apply for the green card.
And what's U?
U means, so C means current. So if you can see EB1 rest of world is current all the time, right? There's not that many applicants. U means unavailable. So there's no visa numbers available.
Okay. Gotcha.
And those are certain religious workers from those countries. And that's a very small quota.
Got it. Okay. Well, that was very helpful. Yes.
Cool. I am useful for a couple of things here and there.
Yes. There are a lot of questions on NTA. I mean, I guess what's the current status is the number one thing on. Have you heard anything?
haven't received any evidence of new NTAs being issued. So our theory that it was a mistake that they've fixed seems to be holding up. We're crossing our fingers, but you never know with these mistakes. They sometimes resurface. Even if they're mistakes, that means people can keep making them, right? So hopefully they've kind of addressed that issue, the core issue that was causing the mistakes, but you got to stay alert just in case they don't.
Yeah. On that note, I did wanted to let people know that we have 2 master classes coming up. So one is immigration options for founder. If you are a founder, that is good one for you. And then we have another one for profile building, which is EB1, O1, and national interest.
Yeah,
So
I mean, if you want to go back to the importance of profile building, why don't you go back to the visa bulletin if you can, Nidhi, to show the difference between the EB1 and the EB2, especially for Indian nationals. Not that you need to be told that, but once again, if this is new to you, I want you to understand something. Maybe if you can go to the final action dates, which are just a chart slightly above that one. And then if you go into India, EB1 is February 15th, 2022.
So first is EB1, like EB. This
EB1, that's correct. Yeah. And
okay.
then EB, the second preference, or EB2, India, is April 1st, 2013. So you might say, well, Samir, that's a 9-year gap. That's pretty sizable. What's the big deal? It's 9 years. This doesn't move linearly. Okay. It's not like every month this advances a month. This might advance a day in 2025, 2026. The projection for somebody who's just getting priority date today in EB2 to get a green card in EB2 India is about 150 years.
Wow.
Okay.
Wow.
Which underscores the importance of boosting your profile legitimately to EB1, which that wait between, once again, that's not a 3-year wait. It's 3 years, 3.5 years ago. It's not going to take 3.5 years to clear. It might take 5 years, for example. Still better than what? 150 years, right?
Yeah.
The importance of profile building is never too early, honestly. You may not qualify next year, but you have to look at the long game. Do you want to wait 150 years so that your grandchildren can apply? Or do you want to be ready in the next 6-7 years? Right? If, let's say, you're a student or a newly minted H1B, for example. Maybe you're not going to qualify for the EB1 tomorrow, but there's stuff that you can be doing right now that'll put you in a better position in a couple of years to apply. So that's what our masterclass will be focusing in on.
Yeah. And they are absolutely free. So link is in the description. Okay. There are a lot of questions, so we'll get started to the questions. Maybe before I get to this one, there was one on H1B wage. Any new update? Are you tracking how many days are left or anything, or no?
Not really. That's just at this point, we're just waiting to hear the updates because I believe the comment period's over. This is the wage. The rule is sitting with the kind of Congressional Budget Office, or just kind of whatever the accounting office or whatever entity is in charge of putting the final touches on it before its publication. So there isn't like a deadline for that. They just kind of take a certain amount of time before they finish, usually a month or two. So so we'll see when it's going to be pretty soon. Remember the rule, I mean, the goal for them is to have this up and running before the next lottery, right? So we should be hearing about something over the next few months, I would say.
And next few months, we will be hearing final rule that they will publish.
Final rule. But remember, just because a rule is published and final and effective doesn't mean it's going to stay effective, right? Because what happens if a rule is illegally constructed or in violation of congressional intent, right? This rule is a regulation, meaning the executive branch, the DHS, the president's executive branch, is saying this is how we're implementing Congress's rule. That's what the wage rule is. Okay. But what if the way they're implementing Congress's rule contravenes what Congress intended in the first place? It contradicts it, right? Then it's illegal, right? But you have to file a lawsuit to challenge that. And that would be the argument here, because Congress said in its rule that DHS or USCIS will find a way to allocate H-1Bs on a first come, first served basis, right? They use that language. So first come, first served doesn't necessarily have anything to do with salary weighting, right? So it remains to be seen as to whether or not this regulation that they're publishing will actually stand up in court.
Got it. Okay. All right. Yudi and Samir, I was on H1B, laid off, changed to B2. I got a job changing back to H1B. Can I work after I receive the receipt notice, or should I wait until the
No,
visa?
you have to wait till the approval. This is not an H-1B transfer. You're changing your status back, so you have to wait till it's approved. We are seeing those cases approved still. It's still happening. So hopefully things work out there.
Nice. Okay. I am a contractor on wage level 3 per Department of Labor data. For EB1A, does wage level 3 qualify as evidence under the high salary criteria, or would only level 4 be considered strong enough? And then there's a follow-up question.
Yeah, I think you're... How am I going to answer this question? I think you're looking at it the wrong way. And I don't mean to be like, snarky there, but the EB1 criteria is much more than just like, am I meeting a certain wage level? It's not formulaic, right? That's a very subjective process, right? You have to show that you're among the best in the world at what you do. That should be the first question you're asking of yourself. Are you among the very best in the world at what you do? Okay. If you're in private industry and you are among the very best in the world at what you do, chances are your compensation will match that, will align with that reality. Okay. So if you're worried about that question, and by the way, is level 3 high enough? Don't look at the wage levels from an H-1B perspective or a perm perspective. Are you making more than 90% of people in your job, in your location? That's what you should be looking at for the EB1. But like, again, if you are among the very best in the world at what you do, the salary should reflect that. If your salary doesn't reflect it, doesn't mean you're not, but it should help inform your kind of understanding of where you are and where you sit. Okay.
But that's like a hard question. If am I the best in the world? Like, how would I know if I'm the best in the world?
Or it's like we're not very good at assessing if we are like ourselves in that way, right? We're always all this negative self-talk that everybody does. We're always like talking crap about ourselves, right? So, but that's the thing. Like first of all, that's what profile building is. Like that's something that's what our bootcamp helps people do. It's a lot of mindset shifting, right? Because the way it works in corporate America is that you're told, and in university and all of our life, even from our parents, we're always told to do what's best for the team, do what's best for the family, do what's best for the country, do what's best for others, right? Don't take credit for yourself. It's not good. It's not a good habit, right? And generally that's true. Like you want to be humble. You want to do what's best for the community, for the team. Generally good things happen to you when you do that, but that doesn't help for the EB1, because for the EB1, you have to talk about why you are the best. And so you also have to, whether or not you openly discuss it, have a very good kind of understanding of, how good you are. You have to be able to, and I think it's a healthy thing to think about why you're awesome at different things. Like that's not being cocky. Like you're not rubbing it in people's faces, right? But you should be aware of it. I think it's a healthy thing, right?
Yeah.
And that's a skill that people are going to have. It's kind of a personal development thing almost. Learn why you're awesome at. Maybe you're not awesome at some things, but you know what you're awesome at realistically, right? And it is a hard thing to do, but it's something that people need to learn how to do if they want to have a successful EB1 process.
Yeah. And Ankit, on that note, you should just come to our masterclass and we can deep dive in those things. I think this is similar. So unless you have a different opinion, like different suggestion for him.
Once again, it's a little too simplistic of a question. Okay.
Yeah.
First of all, let's talk about what the EB1A categories are. If you're in private industry, there's 2 categories that can be really, really helpful to you. They can be the foundational categories, the quote unquote anchor criteria, right? These are critical role and original contribution. So I think you were talking about original contributions here, Ankit. Okay. But let's talk about what they are. First of all, they're both similar in the sense that they are showcasing your impact, your influence, Okay. Critical role is your impact or influence on your organization, usually your company. Okay. Original contribution is your impact or influence on the greater industry, the field, or the world beyond your company. Okay. So based on what you're saying, I think you're talking about critical role because you're asking for letters from your employers, right? But letters from your employers are not going to be enough. Even if there was a second order benefit to the world through the work that you're doing, letters are not going to be enough to prove that to USCIS for original contribution. There needs to be more. We'll talk about it more in our masterclass, but that's a kind of a basic understanding of those two categories and how to think about qualifying for them.
Okay. Approved H-1B, going to India for stamping, working at a large IT services firm on client contract till July 2026. Any risk consular officer will question the employer-employee relationship.
Yes, that's what they. I mean, I think. I'm sorry to say this, but I think if you're in a kind of contractor role, those are the hardest of the H-1B cases. Those are the hardest to get approved. They just are. The government does not like them. The view, the optics on them is that they're taking away U.S. jobs for low-paid labor, right? Whether or not that's true, that's the optics. And so as a result, those optics informs enforcement and adjudication, and certainly at the consular level. So yes, and so it will lean on your company and their attorneys for whatever information you need to take with you to the consulates. They should be well versed in this by now.
Yeah.
So.
Okay. What does row other workers refer if it already has 1 to 5 listings?
Good question. From not those countries. Row means rest of the world. So if you saw the other rows, they listed countries: China mainland, India, Mexico, Philippines. And he's talking about. Oh, I see what you're saying. You have other workers, so between 3 and 4.
Yeah.
Okay, so that is something that it's not going to be mostly you. There's going to be like skilled laborers. Like kind of like blue collar work, like far like certain like immigrant visas that are allocated for very specialized
like
kind of labor.
construction.
Yeah, that kind of stuff. Yeah, low skill stuff. Yeah.
Gotcha. Okay.
But I also meant rest of the world. This is not what Rahul was asking, but rest of the world is also an acronym, ROW, for the first column.
Yeah.
Which is that one. Yeah.
Yeah. Gotcha. Okay. Right. I'm on STEM OPT, laid off, and my unemployment clock is ending in October 8. What happens if some of my interviews are scheduled for November 1st week? If I cannot prepone them, how can I attend those interviews?
I mean, I think you have a bigger concern that if you're going to run if you are accruing too many unemployment days by the end of October, what happens to your status? This is more than just being able to attend interviews. Are you going to lose your student status? Right. So I think that's the preliminary question. And so much less attending the interviews, because are you even allowed to be here? So, talk to your school, understand kind of what you are and what you're not allowed to do, by October end. And then at that point, I would say talk to an attorney. Feel free to contact us if you want a consultation on that one.
Yeah. Okay. I'm on F1 OPT and lost my old passport with valid F1 visa around May 2025. My new passport has no visa stamp. If I got a job, can I go to India now to get F1 visa stamping again, even though I've graduated? Also, can I still apply for STEM OPT and have my employer file H-1B without stamping?
So yes, you will. I mean, if you want to travel, you need a new stamp. You are able to get a new stamp while in OPT because you're still in F1 status. So long as you're gainfully employed, you can prove your status. You deserve a stamp. There's a very tiny risk that if you just have OPT, the government's going to be like, oh, the consulate's going to be like, well, your employment's ending soon. I don't think you're going to come back, and they may not approve you, right? So that's a very small chance of that happening, but it's not non-existent. Okay. You can apply for STEM OPT without stamping, or H-1B without stamping. Remember, stamping is not required for your ability to live in the U.S. It's your ability to re-enter the U.S. after travel. That's all that it relates to. So it doesn't affect your ability to apply for STEM OPT or change your status to an H-1B. Will it cause issues when you need to go for stamping H-1Bs? No. Well, why should it? If you don't have a stamp now and you don't travel, no harm, no foul.
Okay. Can my company apply for my EB2 visa if I prove my value to my manager and he's willing to apply for it while me not being selected through the 3 attempts of H1B?
Yeah, but consider, I'm assuming you're Indian born. What is the benefit of an EB2 if you're Indian born? Remember what I said about the wait is 150 years between the I-140 approval and the you being able to file the I-485, which will then allow you to apply for the work permit. What you're asking for is a bridge to continue working if you don't get the H-1B from STEM OPT, right, onwards. What you need is a work permit, meaning you need the I-485 filed on time. But you're not going to be able to do that if you're Indian born. So an EB2 is not going to be helpful for you, other than giving you a place in line and maybe helping you down the line for an EB1. But it's not going to help you obtain work authorization after 3 attempts at H-1B. What will help you is if you try to go for an O1 visa, a different visa classification. Attend our profile building masterclass. We talk about the O1 as a increasingly used alternative to the H-1B.
Yeah. And this is especially because he doesn't have H-1B. If he had H-1B, then H-1B would just extend or continue. He can
and then you would want to do an EB2 to get your priority date, preserve your ability to continue your H-1B past the 6th year, that kind of stuff. Eventually, if you're Indian, you have no choice but to go for an EB1 or marry a U.S. citizen. So, one is within your control, one is not. Entirely.
Right. Okay. My CPD is in processing and my start date is already passed. It's on September 11th. So what do I have to do now? Rohan, I'm not sure.
Well, Roshan, I hope you're not working illegally. So if you are, stop right away. Contact our firm for a consultation. But you are not allowed to work until you actually get permission to work in this country. And don't mess around, people. Like, we are in an administration that literally are going to use every possible excuse they can to kick you out of this country. Like, they're not playing. Okay. So please be very careful about following the actual letters of the rules.
Yep. Okay. I got selected in H-1B lottery 2024 March with a consulting firm and my 797 approved in March 2025. But I didn't went for stamping yet. I would like to wait for 1 more year and see how things are going on. Is that okay?
That's a long time, like a year between the lottery approval or the lottery selection in March 2024. I assume they filed a few months later, but it took a full year for that H-1B to get approved. My goodness, there must have been an RFE. It must have been pretty painful. It's my guess. But that's how things are with consulting H-1Bs. So I don't know the specifics of this case, but that seems to be what happened here. You don't have to go stamping. Remember, like I said, stamping is only if you want to travel and re-enter. If you're like, I'm not going to travel, then there's no need or requirement for stamping. So no worries.
Yep. Yeah. I'm currently unemployed on STEM OPT. If I am unable to secure a job before my clock runs out, do I need to leave immediately? Will I have some grace period to wrap up my things in USA before leaving?
That's a good question. I don't believe you have a grace period following your running out of unemployment days. I believe the grace period kicks in after the end of a specified program, like your school program or your OPT expiration. Okay. So please do check with the school to make sure on that one, and they can tell you.
Okay. My initial OPT after RFE got approved last week. How many days do I have to secure a job? And I'm planning to go to India next year. What would be pros and cons?
You are allowed how many days of unemployment on the LPT?
90.
That's correct. Yeah. So there's your answer. If you're on OPT, remember you have a lot more flexibility as to what you can do. You can volunteer, you can start your own company, you can do contract work. There's so many different things you can do. And so you have less of a, I don't want to say the word excuse because all of it's hard to do, but you have less of a reason to, use up those days, right? The problem is on the STEM OPT where it becomes considerably harder. Pros and cons for traveling, mentioned them already earlier in this podcast. It's getting the consulate to believe you're going to come back to your home country, to India, after you finish with your student visa program. So that's the risk. I don't hear too much of visas getting denied for that reason.
He's not going for stamping. He's just going for a trip.
Okay, well, maybe stamping. We don't know. If you're stamping, that's a problem. That's the issue, not the problem. That's the risk. Otherwise, you want to make sure you have a job. If you're going to travel, you want to make sure you're able to tell the officer at the airport when you enter that you're maintaining your status, and that would entail you having gainful employment.
Yeah. Yep. Okay. I was laid off, L1A visa, last date October. I also have approved I-140 EB1C with February 2023 priority date from same employer, but I-140 was 485 was not filed. Since my priority date is current, can I file new EB1C I-485 I-140 at all?
Oh man, this is a nightmare scenario. So I'm sorry to hear about the layoff, Dinesh. So last date October, I guess which date is my question? That's kind of important. If that employer did an EB1C for you with a February 2023 priority date, like you can only apply for a green card if you are working for that employer. And the reason for that is like they have to be able to, like you have to submit a form that confirms, that's signed by the employer saying the job offer is still open to you. Okay. So it's largely a question of whether or not that's something they'd help you out with. Okay. But if they're letting you off, chances are they probably won't, because they don't want it to look like to the government that they're giving you something, making a promise to you that they don't mean to keep. Do you understand? So, and we're talking about the dates in October, not September, right? So, and that's when they're laying you off, right? So, you don't file a new EB1C. It's already approved. Let's say you were staying there. Let's say you were still with the company. You wouldn't have to file a new one. It's already approved. You just need the I-485 with the I-45J form. And that's a form that they would confirm that they're still going to hire you. Yeah.
Can you share guidance on how to make sure SEVIS record is set right after H1B cap? I got H1B approved, but withdrawn later due to losing job. Applied STEM OPT one day before the OPT end, but dates are messed up due to H1B cap hold. DSO says that not to change now, but I feel it could impact my case since my present job start date is showing as April.
The short of it is that you really have to work with the DSO to fix this. Follow their instructions carefully. This is like super specific stuff, and there's some questions that I would have for you to get you a better answer. So they're better addressed in a consultation. But yeah, short answer, yeah, definitely work with the DSO on this because they're the only ones who can do that for you.
Okay. If NDS is not the case on H1, is it good idea to change of status within 2 weeks or wait for the last week on 60 days?
There isn't a right or wrong answer. This is super specific to each person. Depends on a variety of factors. Like, what are the chances? Like, how many interviews you got? What are the chances of you getting a transfer filed during the grace period? Are they really, really high? If so, maybe you just wait for that to happen because it's easier to do a transfer than it is to go to B2 and then back to H1B. If you're not feeling great about it, maybe you do a B2 a little earlier in the grace period, such that in case you got an NTA, but you're not sure if you will, but the chances are not existent, but you never know. At least you have something on file to show the immigration court. So I'm sorry I don't have a right answer for you. This is going to have to be one that you weigh the factors in your life and make that decision that you think is best for you.
Is it possible to have an I-140 approved without ever working for the sponsoring employer? I already have an approved perm from that company. In 2 years, I expect my current employer to file I-140 for me.
So, and I kind of alluded to this in the EB1C question. Like, I just realized that I said something that may have sounded weird. I'm like, you have to submit this form for them to confirm that they have a job open for you. And you're like, what do you mean? I've already been working for them. So the I-140 is a job offer for when you get your green card.
Future, yeah.
Okay, so that's what I meant. It's kind of a legal fiction that doesn't match up with how life works, but that's how it works in the immigration rules. That pertains to this question, right? In theory, the answer is yes. You can be on an H-1B with company A. Meanwhile, you got company B over here doing a permanent I-140 for you because their job offers for when you get the green card, which is in the future, right? So in theory, you can do that. However, watch out for doing that because there are higher rates of fraud, obviously, in those cases, where you're going to be like, oh, I'll work for my company, Google, but I'll have my uncle over here file a permanent I-140 from his company, and I'll get a green card through them. I don't need Google, right? Because of the high rates of that happening, which they do happen, unfortunately, it's probably a higher probability of investigations when you're being sponsored for an I-140 by a company that you've never worked for. Even though it's technically possible, watch out.
Okay. I was on H-1B with my former employer, but was laid off, starting my 60 days grace period. During that time, I filed for change of status to F1 with Form I-539, but my first submission was rejected for a payment issue. I corrected, resubmitted after receiving the denial notice beyond the grace period, and USCIS accepted it. While that change of status is pending, my new employer has filed a H-1B petition. Given this, what is my current immigration status?
Oh my God, this is like one of those hypos in a graduate school admission exam. Okay, so you're in a bit of a pickle, okay, because you did not timely file the I-539. It was rejected for a payment issue. The government can consider that to be your mistake. Okay, so that means you filed outside the grace period, meaning you were not in status when you filed for the change of status. So that pending application is going to get denied, probably. Okay, the H-1B, if they file that as a change of status, is based on the validity of that pending application. Do you understand? So it's kind of based on a house of cards here. So what I would do if I were you, you have an H-1B, it's great. An H-1B petition is actually two things. It's the H-1B, like, do I have permission to work as an H-1B holder, right? And in which manner can I activate it? There's two things that happen when an H-1B is approved. Okay. In this case, they'll probably approve the first part. Yes, you are eligible for an H-1B. You've had one before. You have a degree, blah, blah, blah. Job looks legit. But they're probably going to make you leave the U.S. and come back in to activate it. Now, here's the problem. You are out of status, meaning you overstayed your H-1B. You are in danger. You have a visa stamp, H-1B stamp on your passport. You need to talk to an attorney because there's a possibility that stamp is revoked as a matter of law because you overstayed. So if you're going to have to leave the U.S. to come back in, you may have to get a new stamp. So there's some complications there. Talk to an attorney. You can talk to your H-1B attorney to figure it all out. But this is kind of where you stand.
Any news about F1 visa rule change proposed recently? How likely will it be applicable starting next year?
Well, I'm not sure if you're aware of the F1 kind of proposed rule that was submitted for publication, which we talked about extensively in some prior podcasts. So go back and listen to those if you're not aware of them. In terms of how likely it'll be, we have no idea. Once again, we're not sure if those rules are going to pass the muster, kind of the scrutiny of a lawsuit, right? So it remains to be seen. We just don't know enough yet.
Yeah. And it's also in the comment period, or is it the
That's
comment?
that's in the comment period, I believe.
Yeah.
Still,
Mm.
so it should be coming to an end fairly soon.
Mm.
Yeah.
Okay. Currently, my H1B status is I-797 approved. What happens to my previous B1, B2 if I go for H1B stamping now? If my H1B visa approves, or what happens if H1B visa denies?
So typically, let's say this person has a B1, B2 visa stamp in their passport. They're going for H1B stamping. Typically, those are two completely separate things. Typically, they don't do anything to the B1, B2 because the idea is, what if later on you're no longer an H1B? You still should be able to use your B1, B2 to visit the US, right? So there are two different things. One's approval or denial does not generally cause or have any implication on the other. Okay. But that being said, you got people doing this, and sometimes they can be vindictive. They can issue the H1B and cancel the B1, B2 just because they feel like it. You never really know. I've seen that happen before. So.
Okay. I think we already answered that. How can I apply for EB2?
I love
it. Oh, that's funny.
Thank you for that, Karan. Appreciate it.
What was the update on F1 visa? For people like me with Indian nationality living in Dubai, do we have to take the F1 visa student interview in India only? Is the change implemented? Oh.
Yeah, well, it's not just the F1 visa. It's anybody applying for any visa stamp have been ordered to apply in their home country, unless you have residency in a different country, right? So if you're living in Dubai, do you have residency there, right? If you have residency there, there's different ways to prove that. You could, in theory, apply there, right? Definitely talk to somebody to make sure that this is possible for you, but that's the general rule. The change that changes, that's like a policy. Like they just basically announced it and it's effective right away. So yeah, and that happened last week. So a little more than a week ago.
Samir enters the chat and hacks the best in the world. Oh, just kidding. You're getting some fan following here. I got a question. A friend of mine got his H1B, selected this lottery. He did premium processing and got H1B approval notice and I-797, I'm assuming, 47, on July 24th. Unfortunately, he got laid off after that. There's a follow-up question. His employer has not withdrawn the petition yet. What should he do now? His change of status is still scheduled on October 1st, and his university DSO have scheduled F1 to be end on, and he doesn't have a job. Ooh.
Bummer. Could you go back to the prior screen? Does he have STEM OPT?
Doesn't say that.
That's a question I would have. And what would happen? Let's say he never had the H1B. Like, what would he be doing? Would they be working on the STEM OPT? They need more information. Like, if they were, then they need to inform their school right away, because what happens when October 1st hits or thereabouts, maybe a little after, is that whatever kind of system the government has kind of sends this message that eventually ends up in SEVIS and cancels the SEVIS because they're like, this person has an H1B, and they don't actually kind of combine that with the withdrawal. Like they don't put two and two together, right? So you have to go to the DSO to make sure that they put some sort of block or are aware that this message is kind of making its way towards SEVIS, and they keep it from canceling the SEVIS if there is in fact an ability for this person to stay in the US.
Yeah. Okay. My STEM OPT end next year, May, but I'm building my profile for EB1. It will take another 1 year for applying EB1. Until then, I'm planning for day 1 CPT PhD course. What's your suggestion?
About what? As to which course to take? I guess I'm not sure I understand what the question is.
To do day 1 CPT, I'm assuming that's the question.
Should you take day 1 CPT because your STEM OPT is over?
and he's planning to apply for EB1.
I mean, if you've heard me on this podcast, you know how I feel about day one CBT. I don't love it. And I feel like it's going to be on the chopping block with this administration. I'm not even sure they're aware of it right now. I think they have so many other things they're doing that this may be a kind of small fish for them. But at some point, I believe they will become aware of it. And once they actually look into it, they're going to hate it. And they're going to stop it. So I think it's risky to be on day one CPT. But that being said, as things stand right now, people are on it and people have done it successfully. So that's a call you're going to have to make. I would much rather, if you're building your profile, I would much rather you look at, talking to your employer about doing an O1 for you, because an O1 is like it's like an EB1 light, right? It's an EB1 junior. Yeah. And if you're building your profile for the EB1, you may already have an EB1 light. So if that's the case, why can't your employer do an O1 for you? I understand they may have misgivings about it, but at the very least, I would look into having that conversation.
Yeah. Okay. Is there any danger of H4 EAD being discontinued by this government?
Good question. I was just talking about this with a client today. I don't think so. The H4, I mean, who knows? The H4 EAD has survived numerous attacks since its implementation by the Obama administration several years ago. And it continues to stand. It's been pretty amazing kind of watching its resilience. Okay. And I think it was really well written and structured to withstand all those attacks. So I believe it'll continue. That being said, I'm not putting anything past this administration. They're on a different level when it comes to kind of how effective they've been and really kind of battering down the foundations of many things that we've taken for granted immigration wise. So I can't tell you for sure, but my feeling is it's going to continue. So, yeah.
I've heard rumors. Well, not rumors. I've heard third. What do you call third session? Or like I've seen caps Trump 2028. Is that possible?
You've seen? I'm sorry.
I've seen hats which says Trump 2028. So people want him to continue one more. Is that possible?
Is it possible? Are you talking about legally or physically?
Yeah. Legally.
Two separate questions. I'll talk about legally. No, it's not possible. The Constitution prohibits presidents from having more than 2 terms. Now, if there's going to be an argument that's made, it's going to be, they're going to say we interpret the Constitution as saying 2 consecutive terms, and that's not what he had. There was a Biden term in between, so he's eligible. If that's the case, if that's what they want to say, then get ready for Obama 2028, right? I mean, I don't think that's what they're going to be doing. I think it's a lot of talk. There's a lot of talk. Sometimes just like they put a lot of things out there just to stir up the pot a little bit. Yeah, exactly. So.
Yeah. Okay. 2 employers filed H-1B transfers for me. Employer 1's petition, my preferred option, received an RFE, while Employer 2's petition is approved. My question are, what is the typical timeline for RFE resolution once the response is filed? If I join Employer 2 now, would Employer 1 need to file a new transfer later, or can I still rely on their current pending petition once resolved?
Wow, this is a good one. I understand why you're doing 2 at the same time, just because in this market you never know what's going to happen, and you can't really, count on employers keeping you. So you kind of have to look out for yourself. So I don't know. You do. I want to answer the question. What are your thoughts on somebody accepting 2 offers at the same time? Ethically, but do people burn bridges? Do they ever burn bridges doing that, or is it considered?
They do. Yeah, they do. Yeah, because at one point he or she will have to just say no to the other one, and they've gone through the whole process. So yeah, they will burn the bridge.
Yeah, well, that risk aside, that's not really for me to say because I'm an immigration lawyer. But I would say in this case, The typical timeline for an RFE response, once a response is filed, if it's premium processing, they have to respond within 15 business days. If it's not, then it can be up to 2 to 3 months, right? So consider that option. If you join employer 2 now, and then the employer 1 H-1B is approved, then I do believe you can switch to employer 1. But it really comes down to how the petition is drawn and what the approval notice looks like. And that's not something that I have access to. So yeah, you have to work with employer 1's counsel to make sure that you're doing the right thing. And I would talk to them, honestly. You kind of have to ask them. So,
yeah. Okay. I'm on F1 OPT and lost my old passport. I think we already covered this, so I'm gonna skip that. Updates, already covered that. I'm on F1 visa and my initial OPT start date was on September 5th, but my EAD is not approved yet. So when will my unemployment clock start? After my OPT start date or when my EAD is approved?
It's when your EAD is approved, because you can't start working legally until you have your EAD.
Yeah. Yep. Okay. My father is currently in USA on tourist visa, came here on April 30th and living USA on October 24th on 178th day. How soon can he come back here without any issues with current administration's strict enforcement?
I don't know. This is not something that we can just kind of give. Like, there's no formula for this, right? It's up to the temperament of the officer that receives him when he comes back. He can get somebody who doesn't care because he can tell that clearly your father's a tourist and is not going to move here. He can get somebody that can just be really upset that he feels like here's somebody who he doesn't like, that's like, trying to skirt the line of the 180-day rule, right? And just by kind of doing an end around that and coming back right after they left. So I would say he should wait at least several months, honestly, to be safe. But there's really no way. There's no number. There's no date we can give you that'll protect him absolutely from any strict enforcement. Unfortunately, it's just always going to be a risk. Staying for a long time, staying for 6 months or almost 6 months is it's kind of like, if you do that again, it's kind of like it's going to get increasingly harder and harder for him.
Yeah. What is your prediction about EB3 June 2014? While people may enter file form EB2, are there enough green cards available since USA has moved filing dates to August 2014?
So, I mean, can you go back to the visa bulletin? This is an interesting question. This is like another thing that's come up. So he is EB3 June 2014. Okay. So what country? I believe probably India, but we don't know for sure. And this is the final action. So if you go down to the dates of filing.
Yep.
Okay. So in this case, you look at that EB3 date, August 2014, right? That's a better date than EB2, which is December 2013. Right? Which is weird because you're like, what? The third preference has a more advantageous date than the second preference? And that sometimes actually happens. And when that happens, people who have EB2s approved downgrade to EB3. Okay. And it's pretty easy to do so, okay? Because if you have an EB2, let me think, the EB2 requires a master's degree or a bachelor's in 5, right? But the EB3 just requires a bachelor's degree, right? So a company, you can have an approved EB2 I-140, right? And the company the company needs to do is it needs to file a new I-140 for you. Okay. But I think they have to file a new perm because you can't just file. Oh my gosh, I'm gonna have to go back to actually, I think you can file an I-140 amendment to change the EB2 to EB3. I believe that's possible. But that's a thing. So the question is, can they, first of all, downgrade? They can. And are there enough green cards available since USCIS moved the filing dates to August 2014? So what they're basically telling you, I don't know if how many are available, but they're telling you that you can apply through this mechanism. If you downgrade to AB3, you can apply for an adjustment of status in October. And I don't think it requires you to file a brand new perm, right? But I will need to check in on that because it's been a while. Last time this happened was in COVID. And it was early, like 2021, I think it was. There was a lot of this happening.
Yeah. Any comments on the State Department canceling visas for immigrants here in the US for speech? The State Department hold this much power over visas? Wait, what happened?
Yeah. So this is a good question because, and I can actually give you this podcast next week. Tune in because we have heard of somebody who we're not sure what this means, but they've been called in for questioning. They're sitting here on the H-1B visa. Okay. They were pretty vocal, anti, or just kind of pro-Gaza, pro-Palestinian rhetoric on social media, and then speaking out on the Charlie Kirk assassination. Okay. Both. This person did both, and they've been called in for something. We're not sure what, because we just heard about this kind of second, third hand, but we're going to find out. They're going to send us whatever information or whatever request they got. So that's one thing. Now, what this question is talking mostly about the State Department. So visa stamps, right? Visa stamps limit your ability or allow you to come into the U.S., right? So this idea that the State Department can cancel visa stamps for conduct that they find disagreeable, while it doesn't necessarily comport with the ideas of free speech in the Constitution, right? Free speech is constitutional protections are for those that are physically in the U.S., right? Visa stampings are for those who are coming into the U.S. So you are not protected by the Constitution technically for visa stamping. They can cancel visas for speech that they don't like. They actually do have that power. Okay. They generally have to tie it in to some sort of like concern for the common good, because the reason that they give you visa stamps versus not others mostly is because they're trying to protect the U.S. It's mostly about kind of national security. Right. And so the reason that they've tied this kind of visa cancellation into two main areas, which are kind of the pro-Palestinian and the Charlie Kirk assassination, is because they're both tied to what concepts? Violence, right? The pro-Palestinian can be loosely tied in or somewhat tied into being pro-terrorist, pro-Hamas or pro-terrorist, right? That's a leap of logic they make. And in some cases, it actually is true. In many cases, it's not. But they can say it's true in every case, right? At least they have a legal basis for saying it. And then the Charlie Kirk thing is just about you are celebrating the death of this activist. That means you are in support of political violence. Hence, you are a threat to our country. So they can do that. State Department can do that. Now, can it take away your status if you're in the U.S. physically? Remember, status is different than visa, right? That they cannot do. I mean, or they can try if they make a really concerted effort to tie it into a national security threat. But in that case, Marco Rubio himself has to issue a letter in your case to do so. They can't do that across the board, but they may make an example of somebody. I don't know. So this is why we're curious to see, what this person that we know about, what they received, because actually it's starting to happen. So we'll have more information on that next week.
Wow. Yeah. Okay. Final question. If I quit the job on H1B and move back to India, 5 months later, if my ex-employer is ready to rehire me, do I have to file new petition I-797 again, or can I use the same petition to enter the country?
Great question. So if you quit your job and you want to come back with the same petition, you have to make sure your employer doesn't do what? Withdraw the petition. They're supposed to withdraw the petition after you leave your employment. You know why they do that? Because if they don't, you can theoretically come back and claim back wages for the period of time that they didn't withdraw it. So they're most likely going to withdraw the petition. And if they do, then you want to come back, they have to refile for you. So if you can somehow get them not to withdraw the petition, then in 5 months you can kind of come back. So, work with them. Maybe they can put you on a say to leave. Maybe, if they understand why you're going back and and they're cool with it, work with them to see if that's something they can accommodate you with. But understand their position. Like, they don't know if you're going to come back and claim back wages later on, right? So there has to be some sort of assurance they feel.
Okay. All right. I think we are at time, so we'll go, but we'll meet next week. Same time, everybody. Every Wednesday, 1 p.m. California time. But Samir, thank you so much for doing this, and we'll see you soon. And thanks everyone. If you want to sign up right now. I think we have limited seats, so it's going fast, very quickly. Thanks everybody. We'll talk soon.
Thank you.